Friends, we do understand that knowledge is power, and if you exercise power without knowledge, you'll probably be exercising it as an empty vessel filled with nothing. When you have knowledge, power becomes far more useful, power becomes far more meaningful. And to acquire power, knowledge is inevitable. So the success of power is the success of knowledge. And hence, if people who are the real sovereign power vested in democracies, because we say in democracies the real sovereign power vests with the people, if that is true, then people must be empowered with knowledge. And when people are empowered with knowledge, that really empowers society, that really empowers the country. And Francis Bacon rightly said that knowledge is the power, right? I'll give you one more instance where Mr. James Madison, in his writing in 1822, as early as that, had said that, and we know this, that James Madison was involved in the American democracy movement, and probably laid down the path of constitutional democracy per se. He, in his writing, had stated something like this: a popular government without popular information. Popular government is a democratic government, it's an elected government. Without popular information, which is the information that public or the citizens require, or the means of acquiring it. So either the information should be available by the government as it is, because I would state that why should I apply for information? It is the duty of the government to supply this information. So we generally say that the government must supply information out of its own instance, suo motu, without being sought for it. Because the government, if it believes that it is accountable to its people, then it must share the information even without being asked for. However, if the government is not proactive enough of supplying the same information, citizens must be given a mechanism to acquire it, is what James Madison very clearly in his writing puts it. And he says that if this is not done, if popular information is not shared by popular government, then it will lead to some kind of tragedy. It will lead to a farce, and democracies will probably fail, is what he anticipated in his writing in 1822. So this clearly lays down the values of democracy, the values of government in a system. And I think it is very important that information is shared, and that is what the right to information legal regime is all about to acquire. Also, and probably this is the last kind of statement that I would want to make before we continue with our discussion on the constitutional aspect on right to information, is that freedom of information is a reflection of a culture, institution, and growth. It means that if Indian culture stands for secrecy, then we would probably promote secrecy and not go in for transparency. But I think in India, the culture is very clear that even with terms of education and knowledge, please note, in Indian culture, we always believe that education and knowledge is to be shared. We have always believed that knowledge is to be open. It has to be something that needs to be communicated. Everybody must have access to knowledge. Everybody must have access to information. So the Indian society, in its culture, believes in openness. It does not believe in closed society or closed minds. And the institutions that were developed in India, pre-independence and post-independence, I think some of these institutions, the institutions right from a family to that of a society to that of government, have always believed that secrecy should only be used in exceptional circumstances, whereas it must be open governance, open and transparent governance as well. When the culture of any given country and its institution believe in openness and practice the same, I think growth in those societies are inevitable, and I think people will be far more happier than they are in closed societies. And hence growth, yes, in terms of economic sense, but growth in the happiness index is real growth that people aspire for from democratic institutions. Right, with these three icebreakers of statements, I think they fortify the constitutional aspiration on right to information. We will continue with our discussion now on the case laws or the judicial interventions, how the judges, how the judiciary went ahead and contributed to the legal regime on information. We'll continue that discussion with this case, which is a case that talked about the responsibility of local governments. The Bombay Environmental Group versus Pune Cantonment Board. Now, the Supreme Court in this case talked about group rights, about who is responsible for the environment. Now, when development takes place, environment unfortunately is crippled. Development actually is at always the cost of environment. Now, if environment is damaged, your right to clean air, your right to clean water, your right to health are all adversely affected. And hence, when government goes about sanctioning developmental projects, has the government applied its mind on environmental concerns and issues? If the government does not do it, can non-governmental organizations act as watchdogs for the protection and conservation of environment? Can societies take upon themselves the duty to protect the environment if the government does not do the same? So, if you talk about local bodies, that is the municipal councils or municipal corporations, generally they give permissions for various construction projects. These are construction real estate projects. All cities in India are currently growing. There is a massive growth of urban areas. Apartments have come in all places. Unfortunately, when cities start growing, either they encroach upon common spaces or lung spaces or forest areas or lake beds, or they go about rampant violation of the aspect of community property or common property resources. Unfortunately, because there is connivance and corruption between the real estate mafia or the builders with the government easily goes about giving sanction for such projects. And then what we see is clear violation of law, clear violation of environmental protection, and this results in infringement of rights of citizens. And hence, when government goes about its decision-making process, especially in the field of environment, should the government involve people into such a decision-making process? Should the government share information about how these projects are sanctioned? What is the process in which it was sanctioned? Who sanctioned it? And what were the papers and the documents that were submitted to seek such sanction? Now, interestingly, municipal authorities preferred not to disclose this information, claiming confidentiality, claiming competitive interest. But unfortunately, this information is not shared. Naturally, the local people will feel that the real estate builders are violating the law. They're taking the government into confidence by actually engaging in corrupt practices, thereby an irreparable damage to the environment is caused when such decisions or actions are taken. And hence, in this case, the court says that when it comes to environmental impact of developmental projects, it is inevitable for the local authorities to share information with the concerned individuals or group of individuals, which means that NGOs who are working for the cause of environment, NGOs who are working for the cause of human rights, must be able to access these grant or sanction plans, because let them check whether there has been clear application of law or whether there has been violation of law. I think it is important for all of us to understand that it is not the only business of the government to protect the environment. I think it is the business of each individual, each citizen who should go about protecting the environment. And hence, if I have to go about my right to protect my own environment, I must be equipped with the knowledge, with the information that is more relevant to me. I must not be probably instigated by any group. I must be able to have an independent opinion about what is right and what is wrong. Should I go with the right or should I actually go with the wrong is some kind of a decision that an individual ought to make. So I think, does a citizen have a right to demand these sanction plans and documents or approval letters? I think with this case, it was amply made very clear by the Supreme Court that the accountability of the local bodies is towards the citizen, and whenever they take any decision that may have an adverse impact on citizens' right to clean and healthy environment, they ought to share that said information with the citizens. This was made very clear in this particular case. I think so far we have discussed multiple cases which the court makes the suggestion of disclosure of information, makes the suggestion of accountability. And in all these cases, we have seen that the citizens were successful in convincing the judiciary about the need to share information, the need to disclose the information. However, when we say that the freedom of information is a right, is a freedom under Article 19, we ought to know that none of these freedoms or rights in any constitution can be made absolute rights. There ought to be a balance between what can be shared and what cannot be shared. There ought to be a balance what should be kept as secret and what should be made as transparent. And hence in the Dinesh Trivedi versus Union of India case, Dinesh Trivedi happened to be a member of parliament from the Rajya Sabha, demanded that the union government make a report public. This is called the Vora committee report. And they said this committee report was paid by the government and the report was submitted to the government, and hence the report should be made public. It should be released, is what he demanded. And when the government refused his request, Dinesh Trivedi went about to file a case in the Supreme Court asking the Supreme Court's intervention to release this. Now the union government actually refused to do it because they said that this report consisted of information that is gathered from various intelligence agencies. In India, we know that security is something of a top priority, considering the numerous terrorist attacks, the numerous criminal cases that have arisen due to outside intervention, be it in those areas where there is terrorism or in those areas there is Naxalism. I think India has faced numerous challenges, especially on armed aggression or internal violence that has emerged from different groups, be it in the northeast or be it in states like Jharkhand and Chhattisgarh. But in 1977, India had just developed some of its intelligence agencies to gather information so that it can either prevent attack from countries like China and Pakistan, or to actually look at maintaining domestic law and order. So the Vora committee report, interestingly, had access to certain of this information, and they had actually incorporated those information in the report as well. And hence the government thought the report being confidential should not be leaked. So this was some kind of a defense of the government. However, the allegation that was made by Dinesh Trivedi was that the government was suppressing certain facts. And hence the Supreme Court had to decide, by reading the Vora committee, whether this can be a part of disclosure in the public domain, or was the government right in withholding the same. And I think this is a very delicate balance the court must perform in terms of what is necessary to disclose and what is not necessary to disclose. And hence the court in this case said disclosure of the Vora committee report should not be done. Such full-scale disclosure can infringe public interest instead of aiding it, and hence there has to be some means of regulating or restricting the freedom of information. So the government of the day was right in withholding the same, and I think what the court said was, in a constitutional democracy, it is very understandable that citizens are very anxious to know every business or affair of the government. This anxiousness is justified. However, the citizen must also note that the government cannot probably release some information which probably is in their own welfare, in their own interest, and hence by no means can we assume that the right and the freedom is an absolute one, and reasonable restrictions can definitely be applied to the freedom of information law. This, I think, is something that is quite uniform all across the world. I think all democracies share information, but with some exceptions as well. The next set of cases that the Supreme Court decided were very, very interesting. I call them interesting for the simple reason is because they make the reading of the law all that more interesting in terms of both if you're a constitutional law student or you are an information enthusiast. But I think here you slowly try to notice the kind of people's movement, especially through non-governmental organizations, who take the cause of disclosure, transparency and accountability. They take the fight. They take it to the Supreme Court. They take it to the High Court. They want the government to be far more expressive, sharing information. And I think that kind of social change or social reform has been caused by the non-governmental movement or the social reform movement, as we call it, the people's movement. They brought this kind of a change, and hence you will notice the next set, or there are two cases here. The first is the Union of India versus Association for Democratic Reforms. This was decided in 2002, and in this case, the issue was very simple. Do voters have the right to information? So when I exercise my right to vote, when I exercise my adult franchise, when we talk in India that there is free and fair election, right? To achieve all of these three, what should a voter know before he goes and casts his ballot? Now, in India, unfortunately, when elections are held, candidates have to file papers. They have to file their nomination papers. Now, how far these election candidates should disclose their past history? For example, do the candidate have any criminal case pending against them? Is this something that they should disclose? Now, the reason why this NGO called Association for Democratic Reforms demanded this information, and they wanted candidates to disclose the same before elections, was that let the voters know whether their candidate has a criminal background or not. Now, in India, unfortunately, if you look at statistics, they may be quite shocking to know that today elections are based on muscle power. Elections are contested by people who have violated the law. And these are the same people who get elected as MLAs or MPs and are supposed to have the responsibility of making the law for the country. So this was a strange contrasting situation that was happening in India, unfortunately, that muscle power would win elections, and hence the freeness and fairness of elections was largely in a problem situation. So, the very real or the basic information that could be available to citizen is, let him know whether his election candidate has criminal record. If so, what is the crime and what kind of punishment has he already suffered? If suppose he is being punished for more than 3 years, should he be disqualified from standing for elections? I think some of these basic things are something that we demand as voters, and we demand that if we get this information, I as a voter become a more informed citizenry. If I become an informed citizenry, the way I cast my ballot, I will cast in a much better manner in choosing the right versus the wrong candidate. I think the voters have this kind of a right, is what the Supreme Court said, and the Supreme Court simply said the voter has every right to express himself against a candidate who is not competent enough morally and legally to represent him. And hence, if I have to express my freedom of franchise, I must be given the background of this information. And hence the Supreme Court in this case says there is a right to know about electoral candidates. The right to know about electoral candidates is an integral part of right to information as enshrined in Article 19(1)(a) of the Constitution of India. Further, the Supreme Court also says that it's not about the criminal background of the candidate that is alone going to be sufficient. What is most important is probably the assets and liabilities of the candidates. Not only of the candidates, but also their family members. And hence, we must probably know how rich or poor the candidate is. How rich or poor he was before the election, and what is his asset and liability statement if he is going to get re-elected. Because then the candidates clearly will be accountable in terms of how much wealth they have amassed in the 5 years of their tenure as a member of parliament or a member of legislative assembly. Very often than not, these kinds of disclosure post 2002, friends, has brought in some very, very interesting numbers and statistics, and this has awakened the public. Public are more aware that here is a candidate who probably has amassed wealth in public life, and he must be held accountable for disproportionate asset and for corruption, and he must be answerable, and probably he owes no moral and legal authority to represent the citizens as being a lawmaker, especially if you're a member of parliament or a member of legislative assembly. Last but not the least, the Supreme Court in this case says it is important for election candidates to also disclose their educational qualifications. I think whether your candidate is literate or not is not the question. I think what kind of educational qualification you're looking for a candidate. if he's a lawmaker, does he understand the nuances of lawmaking? Probably you can test this. Is he really, something that he can contribute to lawmaking? Is he competent enough, or should we just have somebody else represent us as well? So I think these are certain choices that can be made, and I think the Supreme Court accepts the petition by the NGO, and they say that what has been sought by the NGO is very much valid, and the Supreme Court directs the Election Commission to amend the Representation of People's Act, and Section 33A now reflects this case and its final conclusion. And under Section 33A of the Representation of the People's Act, MPs and MLAs have to disclose before they file the nomination papers. Along with the same, they have to disclose whether there are any criminal cases pending against them, whether they have been punished for a criminal wrong, what are the assets and liabilities of their or their family members, and the educational qualification. This information, if the Election Commission deems it fit, will be disclosed, or we can ask the Election Commission to also share this information under the Right to Information Act. So I think it is very important that a debate in the country has begun on who are our MLAs and MPs, what is their background, what is their antecedent, where do they come from, which family do they come from, what qualifications they have. Interestingly, even now we know whether they have certain assets or whether they are having liabilities. What is their salary? What are their perks and perquisites? I think all of these information the public had a right to know. However, it took this decision of 2002 for the Supreme Court to explicitly state it in no uncertain terms, the duty of the candidates, the duty of the public servants or the public representatives, that before you get the right to represent, you must disclose this information. Right? So this is pre-election information disclosure. I think you will clearly notice that these legislature are also public servants. They're accountable to the public, and they have a duty and obligation to disclose as well. The second case, as I told you, on the antecedent of election candidates is this case on People's Union for Civil Liberties versus Union of India. This is a 2003 case. The earlier one, Association for Democratic Reforms, was a 2002 case. Now, in this case, this is an NGO called PUCL. They have filed numerous petitions in the court. And what they did in this case was, when you talk about the responsibility of, candidates holding such, information, the Election Commission may choose to disclose or not to choose. Right? So what they held is Section 33B of the People's Representation Act should be negated, should be held as being unenforceable, and should be held to be unconstitutional if the Association of Democratic Reforms law or judgment should be valid. So the court in this case said, like, we will have Section 33A and 33B will be held to be unconstitutional. So this was trying to bring the earlier case into effect and to see that there are no inconsistencies within the People's Representation Act itself. In one instance you ask for disclosure, in another instance you deny it, or you give the power to the Election Commission to withhold that same information. That kind of dichotomy was held to be taken away, and the Supreme Court in this case clearly directs the Election Commission to make a new law and to remove existing laws which probably breed secrecy and which go against the spirit of free and fair election. So 33B of the Representation of People's Act 1951 was held unconstitutional in this particular case. Let's now discuss about reasonable restrictions. I think reasonable restrictions are very important and relevant, and they give you an idea about what is the scope and ambit of the Freedom of Information Law. I'm sure most of us have realized by now that the scope and ambit is not an absolute one. Though it is available, there are certain reasonable restrictions that can be imposed on the same. Remember, they are not mere restrictions, they are supposed and considered to be only reasonable restrictions. And hence, if right to know is enumerated under freedom of speech and expression, which is stated in Article 19(1)(a), freedom of information or right to know will be restricted under Article 19(2), which is provided in the Constitution. So the Constitution itself restricts some of our freedoms. And some of the grounds on which freedom of information may be denied, as interpreted and stated by Article 19(2), may be the following. First and the foremost, you may not be given information based on sovereignty, integrity, and security of India. So when it comes to the security of India, when it comes to the supreme authority of the government of India or the integrity of the government per se, information should be denied. And hence the application of reasonable restrictions in the Constitution has huge ramifications about the manner and method in which information or this right to know will be administered in this country. Now, if you look at the sovereignty, integrity and security of India state, you will notice that the same has been incorporated under the Right to Information Act 2005 under section 8. And the similar restrictions do appear over there. And I think what is there in the Constitution also gets reflected in the statute, because you don't expect the statute to go beyond the Constitution. If it does so, the statute itself will become unconstitutional. So RTI just follows the reasonable restrictions as laid in the Constitution, and probably the RTI Act only adds to the kind of restrictions or defines the restrictions in a much clearer and broader manner. So these are some of the exemptions that are there in the RTI Act. So they are kind of aligned and tuned to the Constitution. What is not available under the Right to Information Act are international relations, national security and public safety, investigation, detection and prevention of crime, information from outside government, internal deliberation of the government, disclosure of information affecting the privacy of individuals, trade secrets, anything that affects the government adversely in terms of privileges, and the kind of immunities that certain institutions like the legislature or the judiciary have are also exempted under the RTI Act, right? So these are reasonable restrictions on your right to know as we read it in the Constitution, as also what is read under the Right to Information Act. There are other restrictions as well that continue to operate in India. The major one being the Official Secrets Act of 1923, where we know that information is classified and classified information cannot be shared. However, what is neutralized through the enactment of the RTI Act is probably only section 5, whereas rest of the sections on the Official Secrets Act continue to be in operation. And you will notice that under the Official Secrets Act, the government has the freedom to designate areas as restricted and prohibited, and hence anyone who approaches the restricted and prohibited area or is in possession or transfers any confidential information to any unauthorized person can still be prosecuted under this legislation. So this legislation very clearly declares that there are certain secrets of the government of India which are of national security and public safety. They cannot be handed or handled by unauthorized person, and they cannot be probably transferred to unauthorized person. And if it is done so, it is an offense and you can be punished under the Official Secrets Law. The last law that we will probably have to take due note and consideration of is the Atomic Energy Act of 1962, which also says that certain information under this law is exempted, especially when one reads section 18 of this act. Now, we all know that atomic energy is a national security issue. Atomic power plants are increasing in the country. As of now, as I speak, I think nearly 3% of our energy requirement is coming from atomic sources. Atomic resource is also used for defense purposes. However, when it is used for civilian purposes, especially under the Energy Act, one would assume that the government of the day will have less secrecy and more transparency. However, the Act of 1962 rather speaks otherwise. It probably gives a large amount of exemption to the government while dealing with atomic energy, and it also tells the government that it can not give the same information in relation to atomic energy under any other law for the time being in force. So if you look at section 18 of the law, and this was also something that was challenged in a case called PUCL versus Union of India, the Supreme Court said that the disclosure of information under the Atomic Energy Act has to be restricted. right? And if this restriction is there, I think the court, after evaluating the various restrictions under Section 18, decided that they were reasonable. It was reasonable because the raw material that is used in atomic energy is a special one. It is used for both civil as well as defense facility. Atomic energy is produced only by the central government. There were stringent sanctions on India before India could actually develop its own autonomous and independent capacity towards atomic energy. And hence, keeping the international diplomatic scenario, keeping the domestic requirement of energy security in mind, I think what the court in this case, the PUCL versus Union of India 2004 case, said that this is definitely reasonable and it is constitutional, and there is nothing wrong if the Atomic Energy Act excludes giving information to the general public. So I think by this slide we definitely realize that reasonable restrictions on right to know are available not only under the Constitution but under various special legislations, and hence there is a delicate balance between what to know, what to disclose, and what cannot be done. So in a recent case, Veda versus Union of India, the Supreme Court did hold that government employees also have the right to know. Now, in government, we know that there is something called the annual confidential report, which the senior or the supervisor prepares for his subordinate. Right? Now, the term annual confidential report meant that this would be made by the senior or the supervisor, and this will not be shared with the employee concerned on whom the ACR was prepared. Now, interestingly, in Veda versus Union of India, I found this case to be very important for the simple reason is, if something adversely has been remarked about me or has been something that has been evaluated upon me, shouldn't I be informed about the same? This is a fair question that Veda raised in the Supreme Court. He said that the ACR copy should be made available to him and he should have the right of inspection. So if you realize that when we talk about the right to know, it is not always the government versus citizens. It is government versus its employees as well. The government had a veil of secrecy in preparing annual confidential reports, and hence the seniors would actually pass remarks in the ACR or put certain adverse comments in the ACR. And unfortunately, the employee would never know whether there was any adverse comment or whether he was performing well. And look, to improve my performance, I must get a feedback. And I must be shared with that kind of a feedback. Unless I get a feedback, I will say that probably my boss is happy with me and I'll continue to do the same. And hence, non-communication of ACR was considered as violation of Article 14, which actually advocates the rule of transparency, fairness, and reasonableness. And hence, Devdutt successfully argued in the court that even an employee in the government, so the government, when it talks about transparency, when it talks about openness, it's not only with the citizens, but it must practice the same with its own employees. And hence, it was imperative that all government records, especially in terms of employee-related information, must at least be shared with the employee himself or herself. It need not be shared with the public for A, B, and C reasons. However, the employee has a right to know, because this will only help him develop himself, this will only help him improve if there is an adverse remark, and this will probably help him seek promotion. And hence, any adverse remark on yourself, any feedback, I think the basic rule is, if you apply the principles of natural justice, if you apply the principles of fairness and transparency in public administration, I think all such hearings, all such remarks must be communicated to the concerned individual. I cannot be punished unless I know the reasons for the same. I ought to be informed before any action adverse is taken against me. Interestingly, on medical confidentiality as well, we have very interesting cases about what kind of information can be available vis-a-vis a patient and a doctor. Now, we all know that as patients, you communicate information to the medical profession and you expect the medical profession to keep confidentiality of the same information. But kindly note, while the doctor has access to certain information, he may have to breach that and communicate that information in case it is dealing with certain epidemic diseases or communicable or infectious diseases. And hence, you cannot claim a confidentiality in such matters. I think in such cases, the doctor has a duty to disclose to the district health officials or to the state health officials, because only by that he'll be able to control the disease, right? So in all these cases, you will notice that communication becomes very, very key. I think different professionals and agencies must know when information can be kept a secret and when information need to be shared. It ought to be shared in case it is vital for the community to know. It ought not to be shared in case it is in the interest of the patient or it is in the interest of the individual. So that's the case that was there. And the most popular case on this is on HIV/AIDS itself, X versus Hospital Z. Again, you will notice that in this case as well, community interest was held to be overridden by individual interest, and information disclosure was favored by the court, and the secrecy rule was overridden. We'll come to X versus Hospital Z a little later in the course, especially when we are talking about privacy and right to information. However, at this stage, it is important just to gather this, that I think community interest always overrides individual interest, and information sharing is the rule rather than protecting the information otherwise. This is again a case that displays right to know, especially vis-a-vis private players or private individuals, and the Reliance Petrochemical Limited versus proprietors of Indian Express. The issue that was involved in this case is a very interesting one. It involved the issue of debentures by Reliance Petrochemicals, and the newspaper wanted to publish and print an article on debenture issues because they wanted to enlighten citizens whether debenture is good or bad, whether people should subscribe to Reliance debentures or not. So they wanted to educate the public about the pros and cons of debenture issues, especially keeping the Reliance debenture issue in the case study approach. So they knew that Reliance is coming up with the debenture, so they thought they'll inform the citizens, look, this is what is coming. Should you take or shouldn't you take is what the newspaper was keen to publish. Interestingly, Reliance comes to know about it, and they go to the court seeking an injunction. They say, please stop the newspaper from publishing such a news, because if they do publish, it will affect our business interest, and probably citizens will not go about prescribing or subscribing to the debentures. And hence they said that, look, this publication is not to be considered as a public interest publication. This should not be considered under the freedom of press, and I don't think the public right to know is going to be affected adversely if there is a stoppage on the news publication as well. However, the court overruled this, and interestingly, the court says that right to know is a basic human right. It's a part of right to life. If I have to live, I have to know. So, right to life under Article 21 of the Constitution enshrines the broader horizon of right to know. And it is important as a dimension of new right that this is protected, this is granted. And hence, I don't think the petition of Reliance was appropriate, and they cannot probably ask for a pre-stoppage of such information. I think what they did was not right, and the court rejected that contention. Rather, the court upheld the freedom of the press to go ahead and publish, to educate, to bring about a critical, fair but truthful perspective for debentures and its issue, so that citizens can take an informed decision about whether they wish to invest in Reliance or whether they wish to stay out of it. This is exactly where a trustship role is played by the press. People trust the press to educate them. People, believe that what is said in the media is true, and hence there is a greater degree of responsibility on the media, greater degree of a trust that is imposed on the media, and the media is expected to fulfill the trust in an unbiased, fair, yet in a transparent and reasonable manner. So this is an interesting case of Article 21 being invoked for right to know as being an essential part of right to life. Friends, before we conclude this module, few comparative perspectives on international and constitutional law will be apt and relevant over here. Let me just talk to you about a case in Japan. This is a case in 1969. This is Kanyu versus Japan, where the Supreme Court of Japan held that freedom of the press and freedom to gather news for information purposes and the freedom to report is part of the Japanese constitution. Interestingly, the Japanese constitution then under Article 21 had the freedom of press, like we have under our Indian constitution under Article 21 the right to life. So in this case, again you will notice the Japanese Supreme Court reiterates something that the Indian courts also voiced as the freedom of the press, the freedom of information, and the freedom to report the same. So the Japanese constitution and the Japanese Supreme Court also similarly echoed what the Indian courts did at that point of time. In 1990, an Israeli case also led the Israeli Supreme Court to disclose and state something like this. They said there is an obligation to disclose information that is relevant for the public to know. So the public have a right to know. And under the freedom of speech and expression, additionally, the Supreme Court of Israel says this, additionally, there is a right to receive information. Right? So freedom of speech and expression has an additional right to receive this information. That receipt can be done only by the media and the press, and the public have a right to know, and that right can be only protected and ensured if information reaches the citizen directly. Last but not the least, I am here quoting Article 10 of the European Convention on Human Rights that was brought about in the year 1915. Article 10 states that freedom to receive information includes the right to access data held by intelligence agency. So you will notice that intelligence agencies are not completely going to be excluded from the information movement. I think they also are responsible and accountable to share this information. Interestingly, under the Right to Information Act, even in India, right now, we do not exclude intelligence agencies from the RTI regime at all. They will be responsible in two instances, and I think Article 10 of the European Convention on Human Rights probably just reflects the same. What are those two instances when intelligence agencies will be accountable and responsible to share information? Those are, one, corruption. So in case of corruption, even intelligence agencies will not be excluded. They have to share this information. Second, and more important, human right violation. So when intelligence agencies or the military or the police commit any human right violation, they will be responsible to share the information. They will be responsible to be open. They will be responsible to be transparent. So these two grounds still communicate the fact that the information movement or the freedom of application of information and the right to know do not exclude any agency. I think in an open government, nobody is free from disclosures. Everybody is included, however, with few exceptions that can be put in place. Finally, UNESCO, this is a UN organization, as we know, on culture and on science, and this in its mandate of 1945 had said something like this, that the organization should promote the free flow of ideas by word and image. So I think internationally, freedom of speech, freedom of expression, and right to know have always been intertwined into human rights. And you will notice that countries have always believed that this is an inalienable, basic, inherent human right which cannot be done away with. And I think it is countries' duty to actually protect, nurture, and develop these rights as they go by in their developmental progress. Finally, friends, I'll conclude this module by self-learning questions, and I would expect you to answer the same. Let's start with the first one. RTI is a second generation right. True or false? The answer is false. It's a third generation right. Second, Freedom of press is directly implicit into Article 21 of the Constitution of India. True or false? False. It is directly implicit in Article 19(1)(a). Civil liberties of accused are protected under the Constitution of India. True or false? It's true. It is protected under Article 22 and through various case laws that we have already analyzed in this presentation, including the Prabhadat case and the R. Rajgopal case. So the answer to question number 3 is true. 4. Media have under Article 19(1)(a) freedom to interview prisoners on death row. The same was decided in the case of Prabhadat versus Union of India? Yes, that's the case. 5th question. Lok Sabha Secretariat published the document Background to Evolving a National Information Policy in the year 1985. That's the right answer. Right. So the self-learning questions on this slide have been answered by me. In the next slide will be answered by you. I will not answer it, but I'll just go through it so that you can evaluate whether you have learnt it rightly or otherwise. The 6th question is, right to publish contrary views and rejoinder in public magazine was decided in the case of Indian newspaper versus Union of India. Is it true or is it false? Question number 7. In a government of responsibility like ours, where all the agents of the public must be responsible for their conduct, there can be but few secrets. The people of this country have a right to know every public act, everything that is done in a public way by their public functionaries. The above statement was made in the case of dash. It's quite a tough question. I want you to probably find out where this paragraph is quoted from which case. It's a very important statement. It says that a government which is responsible, which is a democratic government, the agents of the public must be responsible for their conduct. There can be just few secrets. There is a right to know about everything that is done in a public way by the public functionaries. That's exactly the statement that comes from this case, right? So this statement was made in which case is the question, right? I can give you two choices over here. One is the SP Gupta versus Union of case. Is that the case in which the judges said the same thing? Or it is any other case, is what you should probably tell me, right? If it's not the SP Gupta case, which is the other case? Probably any case that was decided way back in 1975. Would we want to look into that case? So just check the first couple of cases. Maybe the state of UP versus Rajnarayan. Was that case in which this paragraph was stated by the judges? So that are the two choices. You can come to the right answer. Let's go further. Yeah. Oh, I have the options here. State of UP versus Rajnarayan, SP Gupta versus Union of India, Bennett Coleman versus Union of India, and finally the Bombay Environmental Group versus Pune Cantonment. So among these four, tell me which case was this paragraph taken from. Okay. 8th one, right to vote and right to know was stated in the case of two cases. I think I discussed on the antecedent of election candidates. One was 2002 case, the other was 2003 case. Both the cases were filed by non-governmental organizations, NGOs. I remember the Association of Democratic Reforms and PUC. So one of them actually decided this correctly, right? So tell me which case. 9th, and I think this is very important and relevant, this 170th Law Commission report deals with the right to information. True or false? The 170th Law Commission report dealt with election reforms. It did not deal with right to information. Right, so it is directly relevant to the election reforms that were relevant in reforming the Representation of People's Act or the right to know as to the antecedent of election candidates. So there was contribution from the Law Commission about what kind of election reforms are necessary in India as we progress ahead in our democracy. So the answer to question number 9 is false. I'm just leading you here. And the last question here is, reasonable restriction of right to know was laid down under Article 19(1)(a). This is something that you have to decide. I will not be able to decide for you, right? So friends, with these self-learning questions, I think we kind of conclude module 2 on the Constitution and right to know. I hope you have enjoyed this discussion. It has been an elaborate constitutional discussion about various cases. And finally, I think to sum up and conclude, you will notice that the role of the judiciary is immense in developing the right to know in India, in developing the right to information jurisprudence in India. I think that lays down the clear foundation in the Right to Information Act of 2000.